Hello everyone, I welcome you back to our channel. This is Legal Mindset at the bar, and today we are going to look at a very interesting topic, a topic I've promised you for so long: the defense of suicide pacts. This defense is not so common to many people of you, but now I've brought it to your knowledge. I beg you to subscribe such that we dive into the defense of suicide pacts. Okay, thank you to those of you who have subscribed, because the only way you can empower us is by subscribing. So, what is a suicide pact? What are the fundamental legal principles that govern the offense of suicide pacts? Because it is also an offense in a criminal liability. Now, hang on until the end of this video. I will take you through a case which shall lay down the fundamental legal principles governing suicide pacts. To define suicide pacts in the layman's language, a suicide pact is like an agreement, a common agreement between two or more people. They should exceed two in number to die together with an intention, a settled intention to die together. The authority that provides for the same is section 178, subsection 1 of the Penal Code Act, cap 128, provides that it shall be manslaughter and shall not be murder for a person acting in pursuance of a suicide pact between him or her and another person to kill the other, or be party of the killing of herself or himself, or being killed by a third party. That is a suicide pact. If you continue to subsection 2 of section 178 of the Penal Code Act, it states that it defines a suicide pact to mean a common agreement between two or more persons to die with a settled intention of dying together. I hope now you have understood what suicide pacts means. There must be two people or more who have a common intention of dying together. Now, if you continue to look at the burden of proving a suicide pact, it is stipulated for in section 178, subsection 2 of the Penal Code Act, cap 128, which provides that the burden to prove a suicide pact shall lie on the defense to prove that the person charged was acting in pursuance of a suicide pact. Remember, the general rule is that the burden of proof lies on prosecution to prove beyond reasonable doubt. But now we see here the burden was on the defense to prove to court that yes, the person was killed, but they were pursuing a suicide pact. It's like an exception to the general rule of the burden of proof. I promised you the case, and this is the case of Uganda versus Reverend Father Pokabishenga, a case of 1978. And in this case, Reverend Father Pokabishenga made a suicide pact with the deceased girls. So he wanted to kill himself, and the deceased girls came into common intention with him to die together. But however, unluckily enough, according to Reverend Father Kabishenga, he never died, he survived. Here is what court held. Court held that from the evidence, such as a letter found at Reverend Father Kabishenga's home and at the scene of crime, and the one written by the deceased girls, showing the intention to die together, there was no suicide pact, because Reverend Father Kabishenga also wanted to die with the girls, but he just survived. To him, it was unlucky. to survive. Now, court held that there was a suicide pact and it was not murder, it was manslaughter. Thank you very much for watching Legal Mindset at the Bar. I urge you to subscribe, share with your colleagues if you find our information helpful. If you have any question, which disturbs you, our numbers are there down in the description box. Contact us. We shall help you accordingly. Thank you very much.